Folks, it was my understanding the jury has reached a verdict. Y'all can be seated in the courtroom. Ms. Thomas, it looks like you may have the verdicts in your hand there. Is that correct? The jury has reached a verdict?
Yes, sir.
Okay, if you can hand that to one of the deputies, I am going to go ahead and review the verdict for legal sufficiency, and then I'll publish the verdict. Thank you, please. Mr. Colley, you'll stand and hearken to the jury verdict, please. In the case of the state of Florida versus James Terry Colley Jr., case number 15-1248-CF, verdict as to count one of the indictment. We, the jury, find the defendant James Terry Colley Jr. as follows as to count one of the indictment. Guilty as charged of both first-degree premeditated murder and first-degree felony murder contrary to Florida statute section 78204(1)A. Verdict, count two. We, the jury, find the defendant James Terry Colley Jr. as follows as to count two of the indictment. Guilty as charged of both first-degree premeditated murder and first-degree felony murder contrary to Florida statute section 78204(1)A. Verdict, count three. We, the jury, find the defendant James Terry Colley Jr. as follows as to count three of the indictment. Guilty as charged of the crime of attempted first-degree murder contrary to Florida statute sections 78204(1)A and 777.04. In addition, the jury has found, with regards to whether the defendant actually possessed a firearm, yes. And the jury found as to whether the defendant discharged a firearm, yes. Verdict, count four. We, the jury, find the defendant James Terry Colley Jr. as follows as to count four of the indictment. Guilty of, as charged of the crime of attempted felony murder, enumerated felony, contrary to Florida statute section 782.051(1). As to the additional question, the jury found as follows: whether the defendant actually possessed a firearm, yes. Whether the defendant discharged a firearm, yes. Verdict, count five. We, the jury, find the defendant James Terry Colley Jr. as follows as to count five of the indictment. Guilty as charged of the crime of burglary contrary to Florida statutes section 810.02(1) and (2). In addition, the jury found the structure entered was a dwelling, yes. During the commission of the burglary, the defendant committed an assault or battery upon Amanda Colley or Lindy Dobbins, yes. During the commission of the burglary, the defendant actually possessed a firearm, yes. During the commission of the burglary, the defendant discharged a firearm, yes. During the commission of the burglary, the defendant inflicted great bodily harm or death upon Amanda Colley or Lindy Dobbins, yes. Verdict, count six. We, the jury, find the defendant James Terry Colley Jr. as follows as to count six of the indictment. Guilty as charged of the crime of burglary contrary to Florida statutes section 810.02(1). In addition, the jury found the structure entered was a dwelling, yes. Verdict, count seven. We, the jury, find the defendant James Terry Colley Jr. as follows as to count seven of the indictment. Guilty as charged of the crime of aggravated stalking after injunction contrary to Florida statutes section 784.048(4). Signed and dated by the foreperson this date. Madam Clerk, I'm going to have you hold that jury. Y'all can be seated. What we're going to do, folks, is the clerk's going to ask each and every one of you if this is your verdict, to assure that this is your verdict, and to assure it is a unanimous verdict. Madam Clerk, you may publish the verdict. Clerk, you may pull the jury also.
Ms. Irwin, is the verdict as published your verdict?
Yes.
Ms. Dim, is the verdict as published your verdict?
Yes.
Mr. Carroll, is the verdict as published your verdict?
Yes.
Mr. Boothby, is the verdict as published your verdict?
Yes.
Mr. Powell, is the verdict as published your verdict?
Yes.
Ms. Thomas, is the verdict as published your verdict?
Yes.
Mr. Price, is the verdict as published his verdict?
Yes.
Ms. Wall, is the verdict as published your verdict?
Yes.
Mr. Andrews, is the verdict as published your verdict?
Yes.
Ms. Bose, is the verdict as published your verdict?
Yes.
Mr. Williams, is the verdict as published your verdict?
Yes.
And Mr. Bomar, is the verdict as published your verdict?
Yes. Thank you, Madam Clerk. The jury has been told it is a unanimous verdict. Ladies and gentlemen, your work is not done in this case. As we discussed during the jury selection portion of this case, if the defendant was found guilty of first-degree murder, which you have found him guilty of first-degree murder, we would then move on to a second phase of this trial to make a determination as to the appropriate sentence for counts 1 and 2 of the indictment. So we are going to move forward to that phase of the trial on Monday. So I do need to give the lawyers a few days to prepare for that phase of the trial, so we will not start that until Monday. I'm going to ask that you be back at 8:45 on Monday in the second floor jury lounge. That process will take, we anticipate, 3 or 4 days. When you get here, I'll give you instructions about that process as well. But let me give you this instruction before you go, before we excuse you at this point. The instruction that I've been giving you all along to not discuss this case with anybody and to not do any research of any type, that remains in place. You will, obviously, when you get home or get back to work, people will start asking you questions about your jury service or where you've been for the last week and a half. So please tell them that you are under specific instructions from myself to not discuss this case. Also, don't do any research of any type. Very important to not read, look at, view, or listen to any media accounts of this over the next couple of days. And as soon as we have everybody here at 8:45 on Monday, back in the second floor jury lounge, we'll get you up here and we'll get started with that portion of the trial. All right, anybody have anything to take up before we excuse the jury? Okay, folks, you are excused until 8:45 on Monday. If you follow one of the deputies, they'll take you down to get your bags and then take you back to that parking lot. And thank you, folks. We'll see you next week. Everybody else remains at the jury, having made findings in counts 1 and 2 of the indictment, finding the defendant guilty of first-degree murder, we will then move on to a penalty phase next week, at which time the jury will be asked to make a determination of the appropriate sentence for counts 1 and 2, that being either life imprisonment without the possibility of parole or death. Is there anything we need to take up at this point? Let's start with the defense prior to recessing, and then we'll get back together Friday to address any motions prior to the penalty phase.
Not at this time, Your Honor.
Okay, Steve.
No, that's fine.
Mr. Johnson.
Yeah, the motion that we had addressed earlier has been filed, Judge, so we can move on that. And the defense has been fairly cooperative in terms of the evaluation, and so we obviously want to do that within the next 48 hours.
Okay. Is that currently scheduled, or you're being, obviously?
We're in the process of trying to get it scheduled, Your Honor, but I just want to make you aware that we did file the motions.
Is that motion the same as your earlier motion in limine? You just modified it for the penalty phase, or is there a different motion?
I guess I should have specified it's the motion for the psychological evaluation. The defense has put us on notice of mental litigation.
Okay.
So it's in order to be able to get a psychologist in to evaluate the defendant.
Okay. I presume there's no opposition, but
Well, yeah, legally, we can't oppose it since we've listed a mental health, at least one mental health mitigation expert. So if they're entitled to that, we just need to be present when that happens. And then we'll also coordinate the deposition of Dr. Meadows as well.
so Mr. Colley shall make himself available over the next 48 hours for the mental health evaluation by the state's expert, and defense counsel needs to receive adequate notice of that so they can be present.
Yes.
All right, we will be in recess until 9 o'clock on Friday in this case. We'll take up any pending motions prior to the penalty phase. At 9 o'clock on Friday, I'll ask the state to prepare jury instructions for the penalty phase, have them available by 9 o'clock in the morning on Friday. The defense, if you can provide a list of what you anticipate will be the enumerated and non-enumerated mitigating circumstances that you intend to move forward on. I understand that can change during the course of the proceedings, and we can obviously make whatever changes are needed, but if you can get that to the state in advance, that would be greatly appreciated. With that, we'll be in recess until Friday morning, 9 o'clock. Thank you.
Thank you.